So a couple of key themes I'd like to pick up on just to start this session off. I think we're still waiting for the courts to provide us with a significant decisions on the new Construction Act payment provisions and adjudication provisions. There have been a few cases, but nothing really meaty to date. In terms of NEC3 specific cases, I would say they continue to be comparatively rare. Over the last year, we have actually had 2 Court of Appeal decisions on NEC, well, disputes arising under NEC contracts, which is almost unheard of, but they were heavily fact specific, so they weren't necessarily addressing the issues that would really appeal to us as NEC practitioners in terms of actually understanding and interpreting key NEC provisions. And I think part of that, the reason for that we're not seeing much case law, is because of adjudication, and it's so popular now, and it's a private dispute resolution forum. So we're not seeing a lot of the disputes that are going through adjudication on NEC contracts go to the courts, particularly nowadays when the courts take a much more sort of robust view in terms of attempts by parties to challenge an adjudicator's decision on jurisdictional grounds. Also, possibly to a lesser extent, it may be a reflection of the success of the NEC contracts in actually settling issues and resolving disputes as you go along at the working level. There have been a few cases on the Construction Act, which Inga and Nicola will talk to you about later. We've had Brim's Construction and A2M Development, CG Group and Breyer Group, which sort of touched upon some of the payment provisions in the new Construction Act. But I think, as I said, one of the consequences of sort of the popularity of adjudication is that we don't have that volume of case law that we had, say, 10, 15, 20 years ago in the heyday of the JCT contract in terms of the NEC. In terms of payment and adjudication provisions, I think it would be useful to get more case law, particularly on issues like the toe length clause, and there is still a slight ambiguity in terms of the effect of the Act, and although most practitioners know that effectively toe length clauses which seek to allocate costs of an adjudication in advance, so say a party pays the other side's costs, win or lose, are effectively void under the new Act, but we're still waiting for a clear case to establish that. Although we've had some obiter sort of remarks. There was a case called Leander and Malili where Mr. Justice Coulson sort of remarked to that effect, but we haven't had any clear judgment on that. And I think in terms of NEC cases, I would say that reported, and the emphasis on the word reported NEC cases are thin on the ground, but I think under the surface there have been numerous disputes going to adjudication on the NEC contracts, and we know about that as practitioners in the market. And certainly from our experience, we've handled numerous adjudications on NEC contracts over the last year or so, probably more than usual actually, and this probably reflects the increasing popularity, I would say, of the NEC contract. And some people say that the NEC is like Marmite. You either love it or you hate it. And so, we're self-confessed Marmite fans. So what about internationally? What about internationally in the use of the NEC? Well, we're finding it's still quite popular in Hong Kong. We're finding some of our clients actually using it in Africa and Norway. So it is gaining more ground internationally. I think it's facing a much tougher ride in the Gulf. I was in Doha a couple of weeks ago where we're working on various projects, and I was reading an article, and the article said, the title of the article was, "Is the Gulf ready for the NEC?" And so I asked a few of our clients, sort of straw poll, is the Gulf ready for the NEC? And the answer was unanimously no. And the reasons for that, I think, is that the culture in the Gulf is very much a sort of unreformed dump as much risk as you can on the contractor, full transfer of risk allocation on a turnkey basis, try and achieve as much price certainty as possible. So from that perspective, I think they're not as enlightened as at this stage in terms of accepting the NEC, but I think that will happen over time. And I think it's actually a pity, because I would say arguably the NEC is probably one of the most suitable contracts to be used in a civil law jurisdiction. Most of the states in the Gulf and elsewhere are civil law jurisdictions. Because most civil codes around the world enshrine this concept of good faith, that parties act in good faith. And as we know, the NEC, more than any other contract, it actually has an express obligation to that effect in Clause 10.1. The parties must act in a spirit of mutual trust and cooperation. That's effectively an express duty, rather than a sort of statutory duty in a particular civil code, to act in good faith. One of the things that I'm often surprised about, and we're surprised in seeing the number of NEC contracts that we see going past our desks, is the poor quality of amendments to the NEC, the Z clauses, and also the sheer just lack of understanding of how the contract actually works in practice. We're seeing issues that just stem from a complete ignorance of how the contract works. And particularly in terms of the option C, target price mechanism, that seems to sort of flummox some parties, and which is surprising, because I mean it's one of the most commonly used forms, and we've seen various weird and wonderful amendments in terms of disputes that we've had under these sorts of contracts. One example that we came across was an amendment conflating, it's an option C contract, conflating the activity schedule with the schedule of cost components and trying to use the activity schedule to effectively value the PWDD in an option C contract. And you can imagine that, that it caused no end of problems in terms of actually an adjudicator trying to work out what is he supposed to do in those circumstances. Another example we came across was actually expressing the fee percentage in the contract data as just a monetary sum rather than a percentage. So you go there and you see a monetary sum. But it was clear from the contract that, in fact, the contractor was entitled to fee on compensation events. So it's these sort of issues that stem, I think, from a lack of understanding and make it very difficult for adjudicators to work out what the parties' contractual entitlements are when there are these sort of misconceived amendments to the contract. And I think it emphasises why it's so important that adjudicators in particular, and also the lawyers, if there are lawyers, or the parties, claims consultants, have a thorough understanding of the NEC, because then at the very least you can actually start at first principles, you understand how the vanilla contract works, and then you sort of work out whether or not potentially the amendments actually displace that position. There's certainly authority in terms of interpretation to the effect that where the contract is based upon a standard form, the courts will recognise the importance of certainty and will often be reluctant to disturb what is a well-established or recognised interpretation of particular provisions. So there is some authority, some cases to support that. I think the NEC guidance notes, as we all know, make it clear that they're not intended to be used for interpretation of the contract. But having said that, in practice, I think the courts or an adjudicator will often have regard to them. I mean, I always look at the very good paper that His Honour Judge Humphrey Lloyd did a few years back on the NEC, and he said, in reality, arbitral tribunals and courts will rarely now refuse to look at the NEC guidance notes if presented with them. This is the climate in England and Wales, following what is perceived to be the current approach of the House of Lords to aids to interpretation. So he's saying, it may be an aid to interpretation, it may be part of the matrix. And so I think one of the issues that's coming up is it's important actually to have that background and that in-depth understanding of how the contract works, and look at established sort of understanding of the contract, particularly now that there is so much accumulated knowledge of the contract, more so than in the past. And we can see from the very recent Court of Appeal decision in RWE, N-Power and Bentley, which Inga is going to be talking about, that it's well established that in looking at how the contract works, or any contract, the courts will look at the objective intention of the parties against the factual matrix, and they will read the contract as a whole rather than looking at one particular clause in isolation. And this was a point that came out very strongly in that case, I think. And it illustrates why I think it's important when you're drafting, if it's necessary to draft an amendment to a Z-clause amendment, to actually not just focus on that particular clause, but understand how the whole contract works. And a lot of amendments that I've seen personally that have been in error or been flawed or failed arise because the drafter just didn't consider what I often call as the ripple effect, that if you drop a pebble in the pond, it will ripple. And effectively, it's the same if you amend one particular clause in the NEC. There are so many clauses that are interconnected, and subtle interconnections, that you have to grasp that to actually fully understand and properly amend the clauses. And it's clear from the RWE N-Power case that you can't just rely on an order of priority clause, inserting that in the form of agreement or a Z clause, to save you and give a particular clause that you've amended, say, in isolation precedence. So I think the message is where you do need to amend, the NEC, you should do so sparingly. And also, there's no alternative to precision amendments that take into account the very subtle interconnections between the various clauses in the contract. Another just sort of observation, I think, which I've touched upon and is coming out of some of the cases which we're going to talk about, is that it's very important to have, for adjudicators adjudicating on NEC contracts, to have an understanding and be skilled in the use of the NEC forms. And I would say this is probably more the case than an adjudicator, say a DAB under FIDIC or an adjudicator under a JCT contract. If you're a referring party adjudicating under an NEC contract, you might want to think about when you apply to the nominating body, if there's a space in the A and B application form for a nomination saying, do you require any particular skills or profession, think about whether or not you should say, well, actually, we need somebody with specific NEC experience. And interestingly, I mean, another development I'm seeing is that we're seeing fledgling NEC-specific adjudicator nominating bodies. I sort of, before this session, I Googled NEC adjudicator nominating body, and I came up with Tony Bingham's necadjudicators.org. So obviously it's happening. So that's something to consider, I think. In terms of other developments, well, we've had one of the worst winters in 2 decades and the wettest January on record. And I think a lot of our clients were seeking advice on exceptionally adverse weather, particularly in terms of NEC. And as we all know, Clause 60.1.13 deals with exceptionally adverse weather under FIDIC. And it provides effectively that the contractor will only be entitled to claim additional time or money, a compensation event, by looking at measurements recorded in a calendar month compared with the weather data in a particular area over the last 10 years. And to be entitled to a CE, then the contractor has to show that the weather is shown to have occurred on average less frequently than once in 10 years. Interestingly, then the contractor gets time and money. He gets loss and expense and an extension of time, relief from LDs for that. And this is an interesting difference with other standard form contracts. So JCT, for example, their approach is to have exceptionally adverse weather as a neutral event. So effectively, the contractor gets an extension of time and therefore relief from LDs, but he doesn't get any loss and expense. He gets time but not money. FIDIC, yellow and red book, same position, neutral event. That he gets time, an extension of time, but not loss and expense. I think I've seen some sort of commentators on the NEC saying that this is it's unreasonable for the employer under an NEC contract to bear the costs as well as the everything else in terms of an exceptionally exceptional weather event, and it's argued that, well, the employer can't necessarily control that, and also, unlike the contractor, the employer can't necessarily spread the risk over a large number of projects. Probably a point for discussion, but I mean, one of the issues I think that this sort of highlights is that there's a difference with other contracts, is that it doesn't make that distinction between separate claims for time and separate claims for money. So effectively, it's an all or nothing position in terms of compensation events. And so that's, although often we do see amendments, Z-clause amendments, which seek to establish that. So effectively, they would say, for example, on the exceptionally adverse weather CE or the prevention event CE, an amendment to try and convert that into a time-only, what I would call a time-only CE. We've seen amendments to that effect. Again, a point for discussion as to what we think of those sorts of amendments. So that's just a very brief run through of some initial observations on our side in terms of things that had happened in the last year. And I'm now going to hand over to Inga and Nicola. Inga's going to start by looking at some of those drilling down into some of those NEC cases, and then Nicola's going to talk about other relevant developments. Thanks.
Okay, thanks, Matt. Well, it's nice to have a couple of NEC cases to talk about this year. The first, as Matt said, RWE Power. What we know is that Z clauses have their friends and their foes. I'm looking at you, Glenn. But what we can agree, I think, is one of the more common Z clauses we see is the inclusion of an order of priority clause. And the benefits of that are well rehearsed. But what this case is showing is that these sort of clauses aren't necessarily the sort of ambiguity-busting trump cards that they're sometimes seen as being. And they're certainly not a panacea for sloppy document drafting. The case involved two documents, contract data and works information, that said different things about how we defined completion. And the case is interesting because it's asking us the question, if you've got that situation, do you just go straight to your order of priority clause? Or do you first try and construe the apparently discrepant documents by looking at the contract as a whole? And it's quite nice when both the TCC in the first instance and now the Court of Appeal in February say the same thing. And they have said you do the latter. You look at the contract as a whole, and you may, as in this case, find that what looks on the surface to be a discrepancy isn't in fact there, that there isn't in fact an ambiguity. And what's interesting with this case is the court is saying that in that situation you don't even need to go to the order of priority clause. So the message to take away from that case is that those sort of clauses that are either in a form of contract or we write them in are not, as they often are seen, as being a shortcut in the contract interpretation process. But the court here is saying they should actually be seen as a tool of last resort when looking at how to construe your contract documents. So that's quite interesting. And the next one is also a Court of Appeal case, Northern Ireland Court of Appeal in this case. And it gives some guidance on how the courts will construe the time bars against contractors and consultants in clauses 61.3 of the ECC and PSC. And this case involved the 2005 edition of the PSC, with clause 61.3 having the standard strict 8-week time bar against the consultant, but disapplying that in circumstances where the employer should have given notice of a CE but didn't. And in this case, the consultant had been required in the scope to carry out asbestos surveys in accordance with HSC guidance. But during a meeting, it became clear that the employer wanted more detailed inspections to be carried out. The issue was whether that was a change in scope and whether the employer should have notified the CE under clause 61.1. It didn't do that, though. This is what had happened, because it didn't think it had instructed a change in scope, but it was simply suggesting perhaps a more detailed or better way of doing things. But the employer then said, well, you're time barred when you seek to claim the cost of the extra work because you didn't do so within 8 weeks of the meeting. The court held, perhaps not surprisingly, that it was a change in scope. And what's interesting is they also said that the claim wasn't time barred. And this case examined the detail of the wording in the caveat at the end of clause 61.3, unless the employer should have given notice and did not do so. We're looking at the sort of clause here that is there for the employer's benefit. Okay, so the court said that if, because of that, if there is any ambiguity in the wording of the clause, and hence the circumstances in which the time bar will bite, then it needs to be construed against the employer because it's there for his benefit. But the wording of the caveat is quite clear, so we don't need to talk about ambiguity. The court said the reference to circumstances where the employer should have given notice needs to be assessed objectively, not subjectively. And so on the facts of this case, the employer's mistaken belief, genuine or otherwise, the mistaken belief that it was not giving an instruction didn't change this. And so the case sounds a caution to employers who try to de-link their clause 61.1 obligations to notify a CE from then seeking to activate and rely on the benefit that comes from the time bars under clause 61.3. And turning now to natural justice, but also still within the NEC context. Now, we know that there are lots of ways adjudicators can breach the rules of natural justice. And what we're going to look at here are some cases where it's been okay, recently been held okay for the adjudicator to ask questions and think about things, and other cases where they have gone off on a frolic of their own. But picking up on Matt's point about the importance of having adjudicators who know what they're doing. Being generally very knowledgeable and clever about the form of contract in dispute was held to be a good thing in Farrelly Building Services and Byrne Brothers. The adjudicator here had been criticised by the party who didn't win. They'd been criticised for using their own highly detailed knowledge and expertise of NEC contracts, having written books on the subject matter and so forth. But this had enabled him to ask clever questions of the parties, in particular seeking submissions from them as to whether they thought clause 63.1 required a prospective or a retrospective assessment of CEs, and where was the switch date. So the fact that the adjudicator then preferred one party's thoughts on that over the other and didn't require further submissions didn't amount to a breach of natural justice. And in fact, as Justice Ramsey said in this case, it's precisely because of this wealth of knowledge that these people have that we seek them out and we want to appoint them as our adjudicators. And within the bounds of natural justice, they shouldn't generally be penalised for putting that knowledge into effect. The Brims Construction and A2M Developments case, this is also an example of where the adjudicator has behaved properly. He asked for submissions on a point that he didn't think the parties had properly addressed. Now, a point to take away from this case is that such a call for submissions during the course of an adjudication can be a means of introducing additional evidence, with the court saying here that the fact that he had asked for submissions did not exclude either party from producing further evidence as part of those submissions. The decision in the GC Group case, which Matt touched on as being something which does peripherally talk about the new payment provisions, although there's nothing of substance there for us to discuss today. It's more interesting from a natural justice perspective, because it's suggesting in that case that the scope of the dispute that we as the referring party put to the adjudicator will be relevant in determining whether or not there's been a breach of the rules of natural justice. The point being that the broader, or perhaps less clearly, the dispute is put, or as the court put it, the more permutations are given, then the more directions the adjudicator may permissibly go off on in answering the question without falling foul of the rules of natural justice. But of course, it's always more interesting to look at the other cases where the adjudicator does go off on a frolic of his own. And although they don't set any new law, we've set out two on the slide here, Hillcrest Homes and Beresford, and ABB and Bam Nuttall. In the first of those cases, it's just reinforcing the fact that it will be a breach if you as the adjudicator answer the right question, in this case whether a novation agreement was valid, but you do so on a basis that the parties didn't put to you and you didn't discuss with them. And then, in the last of these cases, unlike the adjudicator in the Farrelly case that we mentioned a moment ago, here the adjudicator went too far in applying his own knowledge of the form of contract by interpreting the party's subcontract, by relying on a clause that neither party had put to him and which they hadn't referred to in their submissions. There have also been a few cases on the effect of adjudicators' decisions. The interesting issue which came up in Walker Construction and Quayside was on the onus of proof. As you know, the established view since the Scottish decision in City and Shepherd Construction back in 2002 has been that an adjudicator's decision does not reverse the burden of proof in subsequent court proceedings. And part of the rationale for this is, of course, the very nature of adjudication itself, that very big matters, increasingly large matters over the course of the history of adjudication, final account claims, are decided within the context of a very rough and ready process that is done in a short time frame and on the basis of comparatively limited documentation. So the argument goes that it would be unfair for any decision that happens, for example, to be in the contractor's favour, to then throw a burden onto the employer to disprove the claim, or the other way around. But the judges in Walker Construction have made some interesting but currently non-binding or obiter comments, suggesting that that's not necessarily always going to be the right thing, and suggesting that the burden of proof may shift. This is a watch this space issue at the moment, but the question posed by the judges in this case was, what if, for example, an adjudicator awards an extension of time to a contractor? Then we know that that decision is going to remain binding on the parties unless and until overturned by final determination. So is it such a stretch to say that it should continue to remain binding during that process until the contrary is proved to a court's satisfaction? So that's the question posed at the moment. And then the last case before I'll hand over to Nicola is on the near-miss theory in adjudication. Justice Coulson in Alexander and Law versus Coveside Construction has rejected the idea that there could be any near-miss theory in adjudication when it comes to enforcement. And the idea here is that the adjudicator in this case had expressed reservations in his judgment, effectively saying that he could have gone the other way if certain evidence had been forthcoming. And the court, in fact, described the adjudicator as having been far from comfortable with his decision. So for the losing party, it was a bit of a near miss. But Justice Coulson had to consider whether such an unsure, bets hedged sort of decision should in any way be a relevant factor when it comes to enforcement. Now, I think we can be comforted by the fact he said no. The adjudicator's decision on a matter is the end of it, unless and until final determination. And any lessening of that principle would undermine the whole adjudication process. So very quickly, I'll hand over to Nicola.
Right, thank you, Inga. So just carrying on the theme of key construction decisions and developments over the past year, I'll look at the first case here on the slide, which was a surprising and somewhat controversial decision coming from the TCC. In the Parkwood Leisure case, the judge decided, for the purposes of the Construction Act, a collateral warranty can and often will be considered a construction contract, and hence the adjudication provisions of the Act will apply to such warranties. The collateral warranty in this case was given by a building contractor to the operator of a completed leisure facility, and the judge said he had no doubt that the warranty was, as required by Section 104, for the carrying out of construction operations. In common with many collateral warranties, the contractor gave a prospective undertaking to the beneficiary that it would complete the works in accordance with its contract with the developer, which sounds fairly familiar from most collateral warranties. The judge did say this didn't necessarily mean that all collateral warranties were construction contracts, but if there was an undertaking in a warranty to carry out construction operations, it would be a very strong pointer. In contrast, he said that retrospective collateral warranties, which only warrant a past state of affairs, are unlikely to be construction contracts. However, it's our experience that that's actually quite rare to see that wording. So although this is the first time in a reported judgment that the court has considered whether a collateral warranty is a construction contract, the prevailing view generally being that it's not, the decision has been criticised by some commentators. If followed, there are various issues which the judgment raises. Firstly, what does prospective undertaking actually mean, and what point are the contractor's obligations past? Would this be completion under the NEC? Would it be the defects date or the defect certificate? Also, how do you apply the payment and suspension provisions of the Act to collateral warranties? These will obviously apply under the main contract anyway. There could potentially be an increase in claims in collateral warranties referred to adjudication, although it's not uncommon to see provisions relating to adjudication in the collateral warranty, as they're often replicated from the main contract. There could be practical implications. There could be various multi-party scenarios, perhaps where there are multi-party or multi-tenant developments, and each tenant then brings a separate adjudication, which may then have a different decision. This would be quite costly and inconsistent for the contractor. There is a possibility that this could increase the use of third-party rights over collateral warranties, but generally it would be quite interesting to see the impact this case has not only on future claims and cases, but also on the drafting of collateral warranties. Now moving on to some interesting cases, just generally restating what can actually be referred to an adjudicator. In the Wales and West case, which actually did involve an NEC3 contract with an option W2, providing for disputes to be referred to the adjudicator, the judgment actually sets out basic principles about how the courts will analyse the scope of a dispute. And basically, it just points out that you have to be very careful when you're trying to narrow the issues that have been referred to an adjudicator. The factors that the court decided they would consider were analysing the relevant exchanges between the parties to determine what the dispute is, but a party can only refer part of the crystallised dispute, the extent of which should be set out in the notice of adjudication. The responding party and that party may then raise factual legal defences and make subsequent representations. However, the scope is not altered by any documents produced after the notice of adjudication, so it's important to remember that the notice of adjudication is key here. Next, we note that Section 1081 of the Act gives a party a right to refer a dispute arising under the contract to adjudication. But what does this mean? In the Hillcrest Homes case, which Inga briefly mentioned earlier, the contractor brought an adjudication seeking, among other things, a declaration that the employer had made a negligent misstatement. The court found that a dispute concerning negligent misrepresentation was a dispute that arose in connection with the contract and therefore was beyond the jurisdiction of the adjudicator. Key to this case was the drafting of the arbitration clause in the contract, which referred disputes under or in connection with the contract. The wording of the adjudication clause followed the Construction Act wording, disputes arising under the contract, and the court determined there must have been a reason for the difference in the drafting. And finally, there is another way to render an adjudicated decision unenforceable, where the dispute arises under more than one contract, which is the final case on the slide. In this case, the court found that the dispute encompassed claims that were arising under 6 separate orders from the main contractor, which amounted to separate contracts, some of which contained materially different terms and could not therefore be viewed as sub-orders under the same framework. A party can only refer one dispute to adjudication unless otherwise agreed, and they can only refer a dispute under a contract as well. So moving away from adjudication now to litigation, and there's been a very interesting flurry of cases that have come to the courts since the Jackson reforms, in the form of the Mitchell case last November, in which the claimant was refused relief from sanctions for missing a court deadline to file a cost budget on time. Now, the flood of judgments that came after this were all related to the Jackson reforms, which were brought in to address unwarranted delay and other non-compliance with court orders and rules to bring a change in the culture and attitude of court proceedings. One of the main reforms being to narrow the circumstances in which relief from sanctions could be granted. The Mitchell case established guidelines to make it clear that relief from sanctions would only be granted by the court if the breach was trivial, being a failure of form rather than substance, or where the deadline had been narrowly missed perhaps, and also where there are good reasons for the default. And it was generally thought that following this decision, the courts would take a hardline approach to granting relief for such sanctions, and looking at the large number of cases that have followed this, it's fair to say there are far more cases where relief has been refused than where it's been granted. Now, a further result of this has been that the cooperation between parties generally seems to have reduced, as parties are often less inclined to agree applications for relief, hoping the other party potentially will be penalised. But the courts have tried to address this there are various cases where the party is penalised if they unreasonably oppose an application for relief, and they're penalised with costs. And as a result of some of these cases, there has been a new civil procedure rule that came into force a couple of weeks ago on the 5th of June, This allows the parties to agree up to 28 days to an extension of time of such deadlines, as long as they don't actually affect a hearing date. It remains to be seen whether this will actually affect the cooperation and improve matters between the parties. And in fact, actually, currently in the Court of Appeal, Lord Dyson is actually hearing 3 post-Mitchell cases which have been lumped together. So it'll be interesting to see what further guidance comes out of these. So it's very much a live issue still at the moment. So obviously, with this kind of strict approach to enforcing sanctions on failures by parties and the unpredictability that may come from this, it may be something that's actually going to start deterring parties from using litigation and may favour other forms of dispute resolution. So it's worth mentioning briefly the importance of mediation, which should not be overlooked, and the recent case of, that should be actually PGA. The court deprived a defendant of its costs as a sanction for unreasonably refusing to mediate. Now, the defendant hadn't actually refused to mediate, they'd ignored an invitation to mediate, and the court considered that such silence amounted to an unreasonable refusal to mediate, which sends out the clear message that parties can refuse to mediate if they consider it inappropriate, and whilst they won't be compelled to mediate, they must at least engage if invited to. So now just briefly going through just some of the other changes in law that we've seen over the past year and we can expect to see over the coming year. I've mentioned already the Jackson cost reforms and the abundance of case law, but following Lord Dyson's additional recommendations in December 2013, the exemption to the cost management regime has been increased from cases with a value of over 2 million to 10 million for cases issued after the 22nd of April. And also the CDM regulations are very much seen to be updated, hopefully coming into force next year. And it's expected that these changes will include the CDM coordinator being replaced by a principal designer who will have a greater influence over design and be responsible for pre-construction coordination. It's expected also to have a simplified structure because the intention is to make the rules much more accessible and easier for everybody to understand, and also the removal of the competence requirement, replacing it with a requirement for appropriate skills. BIM, again, has been increased use generally, and it's quite encouraging to see several bodies beginning to translate the theory around BIM into practical resources for those encountering it, considering how it can be included in contracts as well. So we have the CIC BIM protocol, and also there's a scope of services for the role of information manager and a practice guide for professional indemnity insurance. And NEC last year published a guide of how to use BIM with NEC contracts, showing the industry is looking in practical terms and moving forwards on BIM. In January this year, the Cabinet Office also published guidance on 3 new models of construction procurement based on best practice in the public sector construction. And generally that's all considering early involvement of the contractors at the tender stage and just trying to get the best proposal offered them for cost efficiency. And finally, in our last point of this legal update, the introduction of the late payment of commercial debt regulations last year is of particular interest, as it has been suggested that it may provide a route for recovering a party's own costs in adjudication. Now, the relationship between this and Section 108A of the Construction Act, which allows the parties to agree in writing that the adjudicator may allocate costs, otherwise each party bears its own costs, is unclear. So it'll be interesting to see how many cases there are on this over the coming year. So thank you very much. Hopefully this time next year we'll have a bit more clarity on some of these issues. Maybe you've got any time for questions?